The senator who made Bondi confess she didn't even have the subpoena applications. There is a document that the Attorney General of the United States cannot confirm exists, not because it doesn't exist, because she won't say. Because saying it exists means explaining what's in it and what's in it. The subpoena applications used to obtain the phone records of 8 sitting United States senators is the kind of paperwork that turns a political scandal into a constitutional one. Sheldon Whitehouse walked into that hearing room with the legal framework already built, not a theory, not an allegation. The actual procedural architecture of how the Department of Justice is supposed to work when it wants the private communications of the people writing the laws. He didn't come to argue. He came with the statute. He came with the probable cause standard. He came with the knowledge that somewhere in the DOJ's files, there are subpoena applications that either followed the law or didn't, and that the answer to that question is what Bondi was sitting in that chair to provide. She couldn't provide it, not because the law protected her from providing it, not because a recognized privilege shielded the applications from congressional review, because producing them would require explaining them, and explaining them would require accounting for the distance between the legal standard that governed surveillance of sitting senators and whatever was in the applications that justified accessing 8 of them simultaneously. That accounting is what the hearing was designed to produce. It is what Whitehouse had prepared to demand. And it is what the Department of Justice had decided before Bondi sat down in that chair that it was not going to provide. Let's establish what the law requires first, because the legal framework is the receipt. When a special counsel or federal investigator wants the phone records of a private citizen, they need a subpoena. When they want the phone records of a sitting United States senator, and Whitehouse made sure to repeat that phrase, a sitting United States senator, with the precision of someone who understands that the title matters legally. They need more than a subpoena. They need probable cause. They need a judge to sign off. They need to demonstrate that a crime may have been committed by the person whose private communications they are seeking to access. And the telecommunications companies receiving those subpoenas, the AT&Ts and Verizons, whose general counsels are paid specifically to understand what they can and cannot turn over without legal liability, have the right and arguably the obligation to contest them. This is not a theoretical framework. It is the actual procedural architecture that separates the executive branch's investigative authority from its ability to surveil the legislative branch without constraint. The separation exists for a reason. The probable cause requirement, the judicial sign-off, the right to contest. Each of those steps is a checkpoint. Each one is designed to ensure that the process of accessing a senator's private communications is not a unilateral executive decision, but a legally bounded one that leaves a documented record at every stage, a record that can be reviewed, that can be audited, that can be produced to a congressional committee exercising its oversight authority over the department that initiated the process. That record is what Whitehouse was asking for. That is the specific thing, not a theory, not an allegation, not a speculative claim. That Bondi was declining to confirm she possessed 8 senators, 8 separate subpoena applications, 8 separate demonstrations of probable cause, 8 separate judicial sign-offs, 8 separate decisions by telecommunications companies to comply rather than contest. Whitehouse asked Bondi for the applications, not as a general request for information about ongoing investigations, as a specific, documented demand for the paperwork that the law required to exist and that the committee had the oversight authority to review. The applications are not investigative materials whose disclosure could compromise ongoing proceedings. They are the legal foundation for actions already taken. The surveillance already happened. The phone records were already accessed. The applications that authorize that access are historical documents at this point. Documents that either demonstrate the law was followed or demonstrate that it wasn't. And either way belong in the hands of the committee examining how the Department of Justice has been exercising its authority. She said she couldn't discuss it. He asked whether she even had copies. She said she couldn't discuss whether there was or wasn't a pending investigation. She couldn't confirm she had the applications. The applications for surveilling 8 of her colleagues, 8 senators. No confirmation, no paperwork. No explanation. That answer, the refusal to confirm the existence of paperwork, is not a legal defense. It is not a privilege claim. It is not the invocation of any recognized protection that would prevent the Attorney General of the United States from telling a sitting member of the Senate Judiciary Committee whether her department possesses the documents used to surveil 8 of his colleagues. It is a silence. And silences in hearing rooms under oath on camera are themselves part of the record. They sit in the transcript next to the question that produced them, available to anyone who wants to understand what the Attorney General of the United States chose not to say when she had the opportunity to say it. Whitehouse had spent years on the Senate Judiciary Committee before this hearing. Years watching how institutions protect themselves from accountability. Years understanding the specific architecture of evasion that departments deploy when the paperwork they've generated is more damaging than the silence they can maintain. He had spent those years developing the specific skill that makes oversight hearings productive rather than performative. The ability to ask a question that has only two answers and both of them are damaging. The question about the subpoena applications was that kind of question. Either Bondi confirmed she had them, in which case she had to explain why they hadn't been produced, or she refused to confirm she had them, in which case the refusal itself told the room everything it needed to know about what was in them. There was no third option, no answer that was both accurate and comfortable. He had built the question so that the only safe response was the one that wasn't available to her. The hearing room understood the architecture of what was happening. This was not a performance of concern. This was a senator who had spent years watching how institutional evasion works, how departments deploy privilege claims and pending investigation protocols and deliberative process protections, not to protect legitimate government functions, but to avoid producing paperwork that documents illegitimate ones, deploying the one tool that evasion cannot accommodate: the specific question, the specific document, the specific confirmation that either produces the evidence or produces a refusal whose specificity is itself evidence of what the document contains. He recognized what he was watching when Bondi refused to confirm she had the subpoena applications. He had seen it before. Not from this administration, from organizations that had made the calculation that the cost of disclosure was higher than the cost of stonewalling and had decided to stonewall and wait. He said it plainly. If you appointed me as your special counsel and I wanted the phone records of a sitting United States senator, that is something you would expect me to tell you. The Attorney General would have to know. The FBI director would have to know. The telecommunications companies would have been on notice. The judge who signed the subpoena would have seen the probable cause application. There is a paper trail for this. There has to be a paper trail for this. That is what the law requires. And the paper trail either shows the law was followed or it shows the law was not. This is not a complicated legal question. It is a documentation question. The distinction matters. Legal questions have interpretations. They have frameworks that smart lawyers argue in both directions. They have precedents that can be cited for competing conclusions. Documentation questions do not work that way. A documentation question has a binary answer. Either the document exists in the filing system and can be produced, or it does not and cannot. Either the subpoena application was filed according to the procedure that requires it to be filed, or there is a different kind of problem entirely. Either the Attorney General of the United States can confirm that her department possesses the paperwork for a surveillance operation she is being asked about in a Senate judiciary hearing, or her inability to confirm it is itself the most significant piece of information produced by the hearing. Whitehouse understood the difference. The question he asked was a documentation question dressed as a legal one. He did not ask whether the surveillance was appropriate. He did not ask whether the probable cause was sufficient. He did not ask whether the judicial process was followed. He asked if she had the paperwork. 4 words that contain the entire architecture of accountability for everything that came before them. The process Whitehouse described, from probable cause determination to judicial sign-off to telecommunications company compliance, is designed to be documented at every step precisely so that oversight is possible. Every step creates a record. Every record has a custodian. Every custodian reports through a chain of command that terminates at the Attorney General of the United States. Whitehouse was not asking Bondi to reconstruct a process from memory. He was asking her to produce the documents that the process required to be created. Documents that either exist in the DOJ's filing system or represent a separate and potentially more serious compliance failure than anything the applications themselves might contain. Bondi said she couldn't discuss the details. 8 senators, not one. Not a foreign agent, not a suspected criminal, not a public figure whose communications touched on a federal investigation. 8 sitting United States senators whose private phone records were accessed by the Department of Justice and whose telecommunications providers did not file a motion to quash. Whitehouse made this point with the specificity it deserved. The phone companies had the right to contest those subpoenas. A responsible general counsel looking at a subpoena for the phone records of a sitting senator has every incentive to file a motion to quash and notify the senator whose privacy is being invaded. That's not obstruction. That's the law working as designed. The law provides those protections specifically so that the executive branch cannot surveil the legislative branch without constraint. If the phone companies didn't contest, and the evidence suggests they didn't, the question is why? 8 separate subpoenas, 8 separate decisions not to file a motion to quash, 8 separate failures of the legal reflex that a responsible general counsel should have when holding a demand for a sitting senator's private communications. Either the probable cause applications were unimpeachable in every single instance, or something else was operating in that process. The answer is in the applications, and the Attorney General of the United States cannot confirm she has them. The subpoena applications are in a filing system somewhere. Every step of this is documented. The probable cause statements, the judicial sign-offs, the telecommunications compliance records. This record is building in real time if you want to follow where the documentation goes, what gets produced, what stays buried, what the next proceeding forces into the open. This channel is where that gets tracked. The foundation was now in the record. The surveillance question was documented, not resolved, not explained, but permanently fixed in the congressional transcript alongside Bondi's refusal to confirm the paperwork that would resolve it. That refusal, it turned out, was not the only thing in the room that day that she couldn't explain. The room had been processing the surveillance question with the focused attention of people working through a legal argument. What came next required a different kind of attention entirely. The person who described Epstein's operation most clearly on the public record is not a whistleblower. He is a sitting member of the cabinet. Commerce Secretary Howard Lutnik. October 1st interview with the New York Post. The Secretary of Commerce had been Jeffrey Epstein's next-door neighbor. Their townhome shared a wall. A reporter had asked how prominent men could have associated with Epstein, while a neighbor like Lutnik immediately recognized him as a predator. Lutnick's answer was not what anyone in that room expected from a sitting cabinet member. He said they didn't just see it and ignore it. He said they participated. Then he described Epstein's method, the massages. What he said happened in those massage rooms. And then the line that Whitehouse read into the record. This guy was the greatest blackmailer ever. He blackmailed people. That's how he had money. The greatest blackmailer ever. Those 5 words, in that order, from that source, represent something that no legal privilege and no pending investigation protocol can make go away. They are in the public record. They were said by a named cabinet member in a nationally distributed interview. They described the operation that the Department of Justice closed its investigation into in July of the previous year. They described the economic engine of a trafficking network that produced over 1,000 documented victims. And they were said by a man who was Epstein's next-door neighbor, who, by his own account, recognized immediately what Epstein was and watched the powerful men around him do something other than walk away. That is the testimony that has not been taken. That is the interview that has not been conducted. That is the transcript that the Attorney General of the United States had not reviewed when she sat down in that chair. Those words came from the Secretary of Commerce of the United States, not from an anonymous source, not from a court filing, from a named cabinet member who lived next door to Jeffrey Epstein and described on the record his understanding of how Epstein's operation functioned, who participated in it, and what its true economic engine was. Whitehouse asked Bondi if she had reviewed the transcript of that interview. She said she had seen the clip, but had not reviewed the transcript. He asked if the Department of Justice had interviewed Howard Lutnik. She said no. He asked if they planned to. She said if Lutnik wanted to speak to the FBI, that was more than welcome. Read that answer again slowly. If Lutnik wants to speak to the FBI. The Secretary of Commerce of the United States, who was Jeffrey Epstein's next-door neighbor, who described Epstein's operation as a blackmail enterprise in which powerful men participated rather than merely observed, has not been contacted by the Department of Justice, has not been asked for an interview, has not been invited to provide a formal statement, has not been treated as what any reasonable investigator would recognize him to be, a material witness with direct personal knowledge of the operation at the center of one of the most consequential federal investigations in American history. If he wants to talk, the door is open. Sit with that for a moment. The DOJ surveilled 8 senators without asking. It has not asked the one witness who spoke publicly. The Department of Justice has not reached out to Howard Lutnik, has not sent a letter requesting an interview, has not dispatched an agent to take a statement, has not treated the Secretary of Commerce, who was Jeffrey Epstein's next-door neighbor and who publicly described a blackmail operation in which powerful men participated, as a witness. The department that accessed the phone records of 8 sitting senators without those senators' knowledge has not made a single proactive contact with a cabinet member who gave a nationally published interview describing the operation the department closed its investigation into. That is not a resource allocation question. The Department of Justice is not short of investigators. It is not short of the authority to request an interview with a cabinet member. It is not constrained by any legal barrier that would prevent it from picking up the phone and asking Howard Lutnik whether he would be willing to describe, in a formal setting, what he described in a newspaper. The decision not to do that is a choice, a documented, demonstrable, on-the-record choice about where the department's investigative curiosity begins and where it ends, and the location of that boundary. Aggressive toward some, incurious toward others, is the thing that Whitehouse put into the congressional record in the second part of his questioning. That is the Department of Justice's position on Howard Lutnik. Whitehouse had spent the first part of his questioning establishing that the DOJ had obtained the phone records of 8 senators through a process it refuses to document in public. He spent the second part establishing that the DOJ has not interviewed a cabinet member who described Epstein's operation as a blackmail ring in a nationally published interview. Those two facts, the surveillance of senators and the non-investigation of the man who called Epstein the greatest blackmailer ever, are not unrelated. They are the two faces of the same institutional posture, an aggressive deployment of investigative tools against one category of people and a studying curiosity about another. The department that found probable cause to access the private communications of 8 sitting senators has not found sufficient cause to pick up the phone and call the cabinet member who publicly described the operation those senators may have been investigating as a blackmail enterprise. That asymmetry is not an accident of resource allocation or investigative priority. It is a choice, a documented, demonstrable, on-the-record choice about where the Department of Justice's curiosity begins and ends. The subpoena applications would show which senators were targeted and what probable cause was offered to justify targeting them. The Lutnick interview shows that a sitting cabinet member has publicly described Epstein's operation as a blackmail enterprise and has not been asked a single question about it by the Department of Justice. Both of those facts are now in the congressional record. Both of them were placed there by Whitehouse. Both of them are available to every subsequent proceeding that examines the DOJ's conduct in this period. The receipts are radioactive. That is why she won't touch them. Bondi's refusal to confirm she has the subpoena applications is the loudest answer she gave in that hearing room. Because the applications exist. They have to exist. The phone records were accessed. The law requires applications for that access. The applications are either in the DOJ's files or they were destroyed. And the destruction of subpoena applications for the surveillance of 8 sitting senators would be its own category of legal catastrophe. She knows she has them, or knows she should have them, or knows what is in them. And every one of those possibilities produces the same answer when a senator asks to see them. She can't discuss it. The receipts are in the files she won't produce. The witness is the cabinet member she won't interview. The silence is the answer that tells you everything the documents would confirm. Whitehouse built the foundation. The applications exist. The probable cause statements exist. The judicial sign-offs exist. The telecommunications records exist. All of it is in a filing system somewhere, with dates and document numbers and the signatures of the people who authorized and executed each step of a process that was used to access the private communications of 8 sitting United States senators. That process has a paper trail. A paper trail is not a metaphor. It is a sequence of documents, each one created at a specific moment by a specific person with specific authority. That records the decision-making process of an institution at the time decisions were being made. It does not require reconstruction. It does not require inference. It requires only the willingness of the institution to produce what its own procedures required it to create. The Department of Justice has procedures for every step of the surveillance process Whitehouse described. Those procedures generate documents. Those documents are in the department's files. And the Attorney General of the United States was sitting in a hearing room where a member of the Senate Judiciary Committee was asking to see them. The refusal to produce those documents, or even to confirm they exist, is itself a document of a different kind. It is a record of a choice made in a hearing room under oath on camera by the person legally responsible for the department that generated the paperwork being withheld. That choice is now in the congressional record alongside everything else that was said and not said in that room. It will be there when the next subpoena is issued, when the next oversight proceeding opens, when the next senator sits across the witness table and asks the question that Whitehouse asked and didn't receive an answer to. The paper trail leads somewhere. And the Attorney General of the United States is currently unable to confirm whether she has the first page of it. The subpoena applications are still in those files. Lutnick's interview is still on the record. And Whitehouse's questions, the ones Bondi couldn't answer and wouldn't answer and chose silence over answering, are in the congressional record too. That permanence matters. because the hearing ended. Bondi left the witness table. The cameras packed up. The legal teams gathered their materials. And the silence that had occupied the space between the question about the subpoena applications and the answer that didn't come. That silence is now preserved in the transcript, in the archive, in the permanent record of a proceeding that the Department of Justice cannot revise or reclaim or reclassify as privileged after the fact. The Department of Justice spent months building the architecture of its Epstein response. The curated release, the closure memo, the redaction decisions, the claim of completeness. It spent preparation time before this hearing writing attack lines rather than legal defenses. It sent its leader to sit in a witness chair and answer oversight questions with silence where answers were required and deflections where silence was not available. All of that architecture is now in the same record as Whitehouse's questions. The curated release next to the subpoena applications it can't confirm exist. The closure memo next to the Lutnick interview it never followed up on. The claim of completeness next to the documentation gap that a senator identified in open hearing. The attack lines next to the questions they were designed to deflect and failed to. Whitehouse asked. Bondi declined. The declination is in the record, next to the questions it answered by not answering, next to the silence. Permanent, time-stamped, waiting for whoever comes next with the authority to demand what Senator Sheldon Whitehouse asked for and didn't receive. The paper trail is the law. The silence is the confession. The subpoena applications are in a filing system somewhere. The Lutnick interview is in the New York Post archives. The 8 senators' phone records are in a database that the Department of Justice accessed through a process it will not document in public. All of that is established. What remains to be established is what the application said. What probable cause was offered, which judge signed off, who in the department authorized the process, and whether any of that followed the law. Those questions have answers. The answers are in the documents. The documents are in the files of the department, whose leader just told the Senate Judiciary Committee that she cannot confirm whether she has the first page of them. This record is not closed. It is building. And the next proceeding that examines it will start exactly where Whitehouse left off, with a refusal to produce documents that the law required to exist, and the silence that sat in the hearing room where the answer should have been.